through the computer. Okay, good afternoon. It is October 18th, 2024. We've had a little bit of a hard time getting started today, but we are now going to go ahead and go forward with part one on tricks and tasks of dependency litigation. So this is, and I'll have a few, if I get a little distracted, I'm going to have a few people that pop up on my screen to admit since we've created the waiting room. So if I just seem to hiccup a little bit, that is why, so I can let them in. This is a slide presentation I originally created for Vince Davis in California. He was doing some Saturday trainings that I did with him for about 6 weeks. And kind of free flow of Connie's thinking, whatever was top of mind for the week. And I've created different ones on communication, advocacy, of course. And then this one is more technical because this is more about litigation. This is a fairly long slide presentation. It's about 45 slides and it's very technical. So as I was reviewing for today, I decided to go ahead and break it up into two different trainings. One of them I labeled cross-examination of social workers, and the other part of it is authentication of records. So these are both trial techniques and strategies. Now, the cross-examination of social workers, as you will see, really kind of covers witness testimony, objections, etc. So please feel free to take some notes. And when we get finished, again, we will still try to take some time for some particular questions on this. These two trainings are trainings that, as advocates, you will want parents to watch because this is a part of the preparation that, for instance, as an attorney, I would want my clients to have this information. As an attorney, I typically don't have time to teach them. All right. Oops, sorry. There we go. All right. So the first question is, why are these two skills critical? So these two skills are critical. First of all, the cross-examination of social workers and investigations is because the social workers and the investigators are typically the star witnesses of the child welfare agencies when they're trying to make their case. On knowing how to authenticate records, parents often lose their defenses, are unable to make their defenses because they don't have records that are properly authenticated that they want to use as exhibits. So as I said, I put these together, but we are primarily today just going to talk about the first part of this. Oh, hang on here. There we go. All right, so in the course of proceedings, we have plaintiffs, defendants, and then we have some other odd characters that participate, primarily the guardian ad litems. Most people coming into the child welfare litigation don't even know what plaintiffs and petitioners and defendants and respondents are because they never use those words in normal conversation. But it's very important that they start learning these things at once. There's a whole nother presentation that I do that I just go through all the characters who are participating in the process. But you want to know and you want to teach the families that are going through that the plaintiff is the one who files. That is the petitioner. Basically, it is the child welfare agency most of the time. They present their case against the parent first. They are able to call witnesses. The parent's cross-examination can be conducted against their witnesses, and then the agency gets to rebut. So again, just kind of to restate the way witnesses are called. So the person who's putting on their case in chief or the person who's filed the petition will call a witness. The parent's attorney gets to cross-examine him, and then the agency gets to rebut. Now, in juvenile court systems, sometimes this goes back and forth and back and forth and back and forth, and it just seems like it goes on ad nauseum. And if you have a judge that doesn't keep the courtroom under control, then it becomes very annoying. So there's this round of questioning that, and especially when you have guardian ad litems, multiple parent attorneys, maybe multiple agency attorneys, etc. And then the defendant is the respondent or the parent. Now they are they are part of the plaintiff's proof because, as you will see, the petitioner calls a lot of these witnesses up front, including the parents. But the parents always have a right to put on their own separate witnesses, including the parent themselves. And I'll talk some more about that. They can also recall a social worker or an investigator in their case in chief, but they have to put them under subpoena to do that. So, in other words, the agency starts their case and they call their caseworker, and their caseworker just, blathers on and on. And then you cross-examine them, the defense attorney cross-examines them, the agency goes back, and then that's usually one of the first witnesses they call. And so then later in the case, as more of the case is developed and more evidence is coming out, the parent's case may need to have that witness recalled for additional questions. However, they like to try to avoid that. So it's always important to get them under subpoena. Now, the guardian ad litems are this whole other creature. They serve a little bit different roles in different states, but in the state of Tennessee, they can call their own separate witnesses. Now, they get to cross-examine, which I always fight with them about the order of who's presenting proof and who's cross-examining witnesses because the guardian ad litems are always trying to trip you up. And since we know those who do child protective service litigation, we know they typically seem to side on with the agency. We want them to be participating when the agency is participating, not when the parent's trying to defend their case. All right, so I have found in litigation that the agency almost always calls the parent and treats them as a hostile witness. Now, what that means in the practice of law, when you call a hostile witness, you can cross-examine them on your direct examination. Now, so this understanding of what is cross-examination, what is leading questions, what is direct examination, when you first call a witness and put them up there, that is your direct examination. You are supposed to ask them open-ended questions as opposed to leading questions. So, in other words, you can ask them, what was the weather like Tuesday? But you're not supposed to be able to ask them, isn't it true it rained on Tuesday? And so these agencies like to call the parents first, create this hostile environment, get the parents' anxiety all worked up, get them anxious, get them stumbling over their own words. So, as an attorney, I have always had this question in my mind about whether or not I should advise a parent not to show up on the first day of the case. I have done that once. Now, it's a tough call because as an attorney, you need the parent there to be making notes about what's going on, to help you with the cross-examination. But if we could prevent the agency from calling the parents right away and creating all this anxiety, it would make for a much smoother trial. If they don't call the parent, or even when they finish all their proof, the parent's attorney should always, always, always move to dismiss the case for lack of evidence. Now, the reason that's important is because one of the difficult things about these cases is keeping the litigation on course, keeping the litigation to have some semblance of a regular trial, as opposed to this just like roughshod, talking over each other, wild kind of case that just doesn't seem to have any rules at all. So the parent's attorney should always just move to dismiss the case. That now some judges are lazy and they'll just say, no, it's denied. Some judges will make a more specific statement about whether or not the state has carried enough proof, has put on enough proof to carry the case forward. But there are some cases where they do not. And I'll give you just a quick example. Many years ago, I had DCS open its investigation on this mom who had a child in kindergarten. And they had brought an allegation against her because the child didn't know their ABCs in kindergarten. And, I was able, even after forcing her to testify about every single thing she had done in the investigation, the best she could come up with was that the child was in kindergarten, didn't know their ABCs, and mother was hostile to DCS. And in that particular case, after the state closed its case, before starting the parents' presentation of evidence, I was able to move to dismiss the case, and the court granted it. So then, after the state does that, the parents have the opportunity to put on their case. And in reality, most of the critical witnesses have already testified. However, other witnesses may present evidence of the parents' ability to take care of the children or grandchildren. This is so important, and we don't want to leave this out. There are some restrictions on character evidence, on, motive, some of the details on evidence. I already have a presentation set up on evidence where we'll talk about, can you present character evidence? Can you present evidence of consistent behavior? What are some of those things you can do by bringing in other people who just know the parents? Definitely, if there are people who know the parents and seen them around their child, or seen them try to work with their child in some way, since we know a lot of these are neglect cases that might have to do with medical care or educational issues, call those witnesses to testify. Do a subpoena to the teacher. They may not like it, but if you subpoena them and typically they will call the attorney in advance and say, what are you, why do I need to be there? And, nowadays we can do some of it by Zoom and some other methods to make it a little bit more convenient. But, for a parent to, or for a teacher to say, this parent's been to school, I've talked to them, they seem to be cooperative, especially since CPS and DCS loves to use the allegation that the parents are uncooperative. That one just seems to pop up over and over. The parents are hostile, the parents are uncooperative. So, if we have any evidence that can show that that's, just an anomaly and that's not the parent's normal behavior, then we should present it. Preparing the parent's case for trial is so, so critical. And in the world that we're living in today, we, as advocates, part of what we're going to do is to train parents to help them understand how to prepare their own case for trial. All right, so it's important to know objections when you look at direct examination and cross-examination. So the Johnny Depp defamation trial is all on YouTube. And I will say that that trial is some of the best examples of quick fire objections. I have already taken that video and posted it in the classroom for this training, where you will see. Now, this particular video was where Amber Heard was testifying and her attorney was trying to ask her questions. And Johnny Depp's attorney was just object, 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 object. When you make an objection, you have to state why are you making objections. You can't just say object. So you'll hear the attorney state the grounds. And the most important thing to notice in that is that as this testimony goes on, Amber Heard gets more and more frustrated, more and more distracted. She has a story she wants to tell, and she's not getting to tell it. And this is an important thing about parents trying to tell their story and how these objections can be quick fired at them and be distracting and distressing for them. All right. It's very interesting that how few attorneys really understand objections during the examination of witnesses. Here is just a little hit list. Now, if you're taking notes, I would write down this hit list or take a picture of it with your phone. Again, I will copy these slides and have them posted up in the classroom. But these are the most used objections. And I'm going to tell you what they are, and then we'll talk about them a little bit. So leading, hearsay, speculation, assuming facts not in evidence, cause for expert opinion, improper character evidence, lack of foundation, irrelevant, prejudice outweighs the probative value, the best evidence rule, and outside the scope of cross-examination. Ooh, now, that looks like just a very simple list. This is a very heavy discussion. Again, we have a whole training on evidence. We'll spend a lot of time on where we go through the rules, but let's talk about what a few of these are so that clients and people going through the litigation process can understand. So, a leading question is the example I gave before. So, a leading question is a question that suggests the answer in the question, which solicits a yes or no response from the witness. For instance, isn't it true it rained yesterday? Okay, that is a leading question. Leading questions are supposed to be reserved for cross-examination, but may also be used for hostile witnesses, which is, as I said, the agency likes to call the parents who are hostile witnesses to the agency and then ask them leading questions. You know, parents, this is one place where parents get super, super confused because if the agency starts doing that and starts soliciting a yes, no, there are some questions that are not yes, no responses. And the parents have to be trained to be able to say, that's not a yes or no response. Or they have to be able to say, yes, but I want a chance to explain, which they're allowed to do. If they hem haw around, the agency will typically tell the judge to instruct the witness to answer the question with a yes or a no. But the parent should know and the attorney should know that the parent has a right to either say it's not a yes, no response, or say yes, but, or no, but I want to explain my answer. Hearsay is where hearsay is testimony that is solicited which is basically gossip. I'll just put it that way. You can put if you're making notes, just put a little, you can put in parentheses there, gossip, because hearsay is coming to court and say what somebody else said. So the theory is you can't go to court and say, the CPS investigator told me so and so. Well, let's not use that. Let's say the neighbor, okay? The neighbor told me so and so because the neighbor's not there to be cross-examined. So that's why we have that rule. There are also documents that can be hearsay. So, for instance, a letter. So, if somebody's trying to put a letter into court and the person who wrote the letter is not there to be cross-examined, that would also be hearsay. Speculation is a good one they love to use in CPS litigation, where they speculate about what's going to happen. You know, oh, this child is going to be so distressed if they have to return to a parent, or, this is, this child's not going to do anything that they're trying to predict the future is speculation. Assuming facts not in evidence is a fun one because people try to draw a conclusion about something that might be evidence, but it's not been put into evidence yet. Okay, so where would this occur? Let me see. So somebody might want to talk about, I'm trying to think of examples of these as we go through them to help you a little bit. Assuming facts not in evidence. Okay, so let's say the CPS worker says, well, this child's not doing well in school. Okay, so the CPS worker is not the teacher. They have not submitted the educational documents, so they cannot testify that the child's not doing well in school because that would be assuming facts not in evidence. Cause for an expert opinion. This is one in CPS as well because they're always trying to get their opinions in about how well the child is doing, how they try to even sometimes do double hearsay by saying that the doctor said this or the doctor said this, which is hearsay. Improper character evidence is when you're trying to put in somebody's a good guy or a bad guy, uh, and not really. Character evidence is a little bit more complex. I think I'm going to save the details for that when we go into evidence because I actually have the rules laid out. A lack of a foundation, a lack of personal knowledge, a lack of foundation is an important one because, again, this is kind of like hearsay. It's like trying to testify about something happened, like saying that, the dad parked his car behind mother's car at the Kroger parking lot. All right. So if that person didn't see it or hasn't seen a picture of it, they don't have the personal knowledge and they cannot lay a foundation as to how they would have that knowledge. Irrelevant is a pretty broad one. It just doesn't relate to the topic that is at hand. The prejudice outweighing probative value. This is probably in CPS litigation used most often when somebody wants to get in, let's say, a past CPS investigation that was closed out, or a past criminal arrest that was closed out and not adjudicated. The best evidence rule has to do with uh, when there is evidence of something, but there's documentation to support it. Okay, so if a CPS worker wants to testify about the child shot record or wants to testify about the parents' results of their drug screen. Okay, so the best evidence rule is that you should produce the documentation that supports that, especially if it's in your possession and control. Outside of the scope of cross-examination, this gets to sort of the control of the courtroom. But as I talked about before, the agency puts on their witness and gets to ask their witness questions. The parent's attorney cross-examines them, and then the agency gets up and is able to redirect them. But they're supposed to be limited to redirect them to the questions that have been asked. And this is a really important one to remember when you have a blathering witness, which I'm going to talk about again in a minute. But when you have a witness that just blathers and blathers and you want to get them off the stand so they stop talking, outside of the scope of cross-examination is important. All right, so hearsay. We talked about hearsay, but there are times when hearsay is allowed in a juvenile court or CPS litigation. One of them is about children talking about being abused. Now, this is a hearsay law that has changed. It changed in Tennessee probably 10 years ago. And I think now in most states, there's some type of hearsay allowed for child abuse. It used to be in Tennessee that hearsay, in other words, if a child if a child told somebody they were abused, such as a teacher, a doctor, even a CPS worker, that person could say, "Oh, the child told me. The child told me they were spanked. The child told me they didn't eat dinner last night." So that has been modified just a little bit in that in Tennessee, if somebody's going to use the hearsay rule and the child is 13 or over, that child has to be made available to testify so they can be cross-examined about that. Now, that has put a little hiccup in the state agency's ability to use that rule. It's slowed them down a little bit, but not a whole lot. But they use this a lot when it comes to children who are under 13 and they love to go to school and do interviews with the school. There are which they do, of course, in secret, nobody knows about, and then they take their own notes and then you find out later. So the other thing with children about abuse now is that most states now uh, have official forensic interviewers for children, especially when it comes to sexual abuse. So there are advocacy centers or investigation centers in every state now, I believe. And this is a room where they interview the children, the interrogation room. They're a little austere. They're a little creepy, I think, because these rooms are maybe 10 feet by 11 feet. They have plastic covered furniture and there's a big two-way mirror so people can watch them. And there's like 4 video cameras. So it's a little bit creepy for a child, but in the most part, I think this is a good process because it is video recorded. Those video recordings are made available to parents and experts to testify from. And you can, of course, we know there are sometimes children can be manipulated to say things, but I would say overall, all in all, the video recordings of forensics are important. Now, unfortunately, they sometimes they don't even give you those videos, or they block them, or they lose them, or they don't make them available. Or, we have parents who say, I tried to get the video and they wouldn't even let me look at it. And the reason it typically, if they won't let you look at it, is because it's exculpatory, right? It means it doesn't explain abuse. Now, hearsay, another kind of frustrating one is experts talking about other experts. This is very frustrating because an expert may come to court. For instance, let's say a child psychologist has become involved, and the child psychologist has called the child's pediatrician and asked the child's pediatrician about their doctor's visits or how the parent acts during the doctor's visits. You just don't ever know what type of information they're going to elicit. But the expert witness then can come in and talk about the hearsay information that they garnered from these other outside experts. This is a reason why it's really important, and we'll do a whole training about experts, what you have to know before you get started with an expert. So there's, you ask for their CVs, their curricula vitae, resume, etc. You ask for, there's a way to ask for all facts they're going to rely on. And if you do not do it, if a parent's attorney does not prepare to rebut the expert witnesses, I guarantee you they're going to get hammered in the courtroom. So the probable cause hearings are the first hearing that they have when a child has been removed. Sometimes they call it the 72-hour hearing, the removal hearing. And this is another very frustrating part for parents' attorneys because they know during a probable cause hearing, the caseworker can come in and say anything. The caseworker can say, even talk about the referral, who they haven't even personally talked to. They haven't even completed investigations, but they can say, well, there was a referral that, and it's even sometimes like double hearsay. It's like the referral said that the child said. Very, very frustrating for parents counsel. And because of that, a lot of parents counsels waive the probable cause hearing or the preliminary hearing. You know, as frustrating as they are, my advice is never, ever, ever waive a probable cause hearing. Judges don't like it when you ask for them, but you need to get all the information that you need as quick as you can get it. Sometimes they drag their feet giving you records. You want those social workers up there or investigators up there. You want to ask them every possible question you can. Now, again, judges don't like it. They get frustrated. Sometimes they cut you off. They're like, oh, this is just a probable cause hearing. But these probable cause hearings on removal are not just about whether there's probable cause of abuse. They're also required under federal law to make a finding that placement in foster care is the least restrictive means. A lot of people forget this and they think, well, the judge is going to find probable cause because they can talk, they can give hearsay. But this is a huge opportunity, and parents have to be prepared ahead of time. Parents who rely upon court-appointed counsel don't even meet their court-appointed counsel often until they get to court. So they have no idea how to prepare. But I have used these probable cause hearings to get a hearing on alternative placement right up front out the door. But if you don't know about it, if you don't do it right then of course the children get caught up in foster care. They drag it out, drag it out, drag it out months and months and months and years. And then they come in and they say, well, this child is really settled with the foster parents. So the final one where hearsay is allowed is called a dispositional hearing. And the dispositional hearing is you can kind of break this word down into dispose of, right? So if the court has decided that the state has met their burden, has made their case of dependency and neglect, they have to decide what's going to happen next. That's what a dispositional hearing is. What is going to happen next? Now, they can put the child in foster care, but it says clearly that they can return the child to the parent with conditions, or they can put the child in relative placement or kinship placement. And so this dispositional hearing can also be bifurcated away from the adjudicatory hearing. Attorneys need to ask for this. Attorneys need to ask right up front, Judge, we're going to want to bifurcate the dispositional hearing from the adjudication. They have to ask for it, put it on the record, put it on a piece of paper, file it. And the reason is because these attorneys don't know everything that's going to come out in the hearing because typically they're not 100% prepared. But even if they have records, they don't always know what the testimony is going to be. So you want the dispositional hearing to be separate. These cases are so hard and so so much detail. Hang on here. Click somebody in and I skipped a couple slides. There's so much detail that's required to be addressed. And because the court appointed attorneys, they aren't paid a lot. They're capped off with their time. Our goal is to prepare parents and help parents understand what they need to do to prepare. All right, so the state agency workers, this is one of my favorites here, this Dee Dee Miller. She is the one who created all the chaos in DeKalb County for me and Miss Hancock. And she was quite an interesting character. She made false statements in the petition. She refused to return my phone call. She wouldn't talk to me. And then she got an ex parte order. And so we're going to talk a little bit about the state agency investigators and social workers. All right, so the social workers act as the agency representative. So generally during a trial, witnesses are excluded from the courtroom except for the parties, which would be the parents. So, years ago, I used to object to all caseworkers, all investigators sitting in the courtroom at the state agency's attorney desk. I would say, no, they're witnesses. They need to be kicked out. Well, the judges started letting them stay in there. So the state agencies will put the social worker right beside them at counsel table and claim that they are, quote, the agency representative. And, I don't think this practice should be allowed because they are fact witness. It is at least worthy of an objection on the record where you object and you say they're not a party to the case. They should not be in here during the entire presentation of testimony. So, we even had in our crazy criminal case, one of the DCS attorneys came and sat at the district attorney's chair like they were the victim. So if the social worker is going to be in the courtroom, as an attorney, I always watch them carefully during the trial. I watch them, what they were making notes about. The parents need to try to watch them as well. All right, so what is the purpose of the cross-examination of witnesses? This is the strategy. Number one is to undermine the credibility of the witness. Number two is to undermine the facts relied upon by the witness. Number three is to begin to develop your own response, your own evidence that you need to put on trial through this witness, kind of to try to narrow things down, so to speak. Number four is just to wear the witness out until their testimony wavers. And number five, you want to stop the verbal diarrhea of anybody who's just a liar. All right, so let's talk about this a little bit. These things, credibility, facts, response, and wearing out the witness. This is very, very important that as advocates that we make clear to parents that this is going to be the process. The fact is, it is a torture chamber. I mean, sitting on the witness stand is a torture chamber. I had a case where the opposing side called the mother as one of the first witnesses. She didn't, I hadn't had, I wasn't training people on this. They didn't understand this. I did the best to kind of give them some overview, but attorneys are so busy trying to prepare their case for trial, they can't really prepare witnesses. And so they put her on the stand. They went round and round and round asking her questions. They were cross-examining her about this audio of her husband screaming at her, and she couldn't even recall the audio. We didn't know how they got it, but they just kept playing it over and over. And the whole point was to create so much anxiety in her that she could no longer answer questions. And of course, by the end of the day, she became extremely hostile. And when we walked to the parking garage that afternoon, I walked her out to her car, and I'm going to change her name because I've used this story before. I don't want to embarrass her, but I'm going to call her Debbie. But I said, Debbie, you're going to go home tonight and you're going to take a hot shower and you're going to go drink some tea and you're going to go to bed early and you're going to come to court. And tomorrow, when you get on the witness stand, and the very first thing I'm going to tell the judge is that we have a preliminary matter, and you're going to turn to the judge and you're going to say, Your Honor, I want to apologize for my demeanor and temperament at the end of the day yesterday because I was so tired and exhausted. And she did exactly what I said. It broke the anxiety and the turmoil of the proceeding. And also, the judge was like, don't worry about it, right? So he responded to her. So sometimes you have to, for parents to kind of understand this process of what's working, our goal is to help them work their way through that and not have the reaction that the agency wants them to have, because their story is the most important story in the room. So we also want to undermine facts. This is important for social workers. We want to undermine the facts relied upon by the witness. I'm going to give you a good example. I've had a few cases where the social workers have done that the basis of their investigation is from a teenager, a disgruntled teenager. And if you can identify exactly where they're getting their information from, and you find out, for instance, it's a disgruntled teenager, then you can start undermining the facts that they're relying upon by asking them questions like, unfortunately, I have to say, we have some teenagers that are not very well behaved. And you can say, well, Johnny got in trouble for having marijuana. Johnny's grades were falling. His parent was trying to get him to do better. He had been very hostile and angry at his mother over the past few days. So you want to undermine the facts that they're relying on. So developing a response through the witness requires very, very careful listening. So you want to listen as to what those key points are, because those key points are the things that you want to make sure you put on the rebuttal to those points, so that we can start to chip away. A good attorney is going to, in their closing arguments, be able to say, the state says this, but judge, we showed you this, right? So that's what developing a response is. And it sounds simple. It's not. It's very hard. It's very complex because it requires extreme focus, extreme focus. All right, and then just wearing out the witness, like the example that I was giving to you before. They put a parent on the stand. They keep them up there for hours and hours and hours. And I've been on the stand before and had to testify a couple times. And it's exhausting because it requires a lot of focus. You get dehydrated, everybody's staring at you. So, it can be very difficult. All right, and then we're going to talk about the last one here in another slide. All right, so the credibility of a witness, I put this up here, you're outnumbered because there's going to be a bias in the presentation for the state throughout the whole process. These judges hear these same witnesses all the time. They come into court all the time. I know I was a prosecutor in a general sessions court in Davidson County. I did all these misdemeanor crimes. The same cops were coming in all the time. The same DAs were coming in all the time. We'd see them in the back room, have coffee with them sometimes before we came out to try cases. And so there's already this feeling of being outnumbered. And so when we are trying to cross-examine and sort of stop the damage by witnesses, the credibility of the witness is one of the things that we try to attack. So credibility, bias, prejudice are always relevant. So how does prejudice go? Prejudice is usually the easiest one to show, or the bias. This can be foster parents. The foster parents are biased because they want to keep a child. The caseworker may have some bias or prejudice, especially caseworkers who've had multiple investigations with the family that they've been unable to substantiate. You want to make sure that you bring that up. And this is part of the preparation and part of the getting the records and looking at the records. If you can establish that caseworker has investigated before and didn't find anything, and now all of a sudden is prosecuting a family, that's relevant information. So you want to identify there might be any reasons for bias. It could be religion, race, it could be attitude, right? The status, power, attitude, incompetence. I mean, these are all issues of credibility. With social workers, attacking their credibility on their record keeping is important because they are, as you see in number 6, they are assumed to be prudent record keepers, and they are not. They are not. And attacking their ability to keep good records, which can be, in CPS, I'm going to show you an example, but it can be when they have a meeting versus when they document it. So anything that you can do to undermine the power of their testimony, it's important. They're going to be identified by the judge as credible before they even open their mouth. Okay, so credibility on the facts that are relied upon. So we have two situations with caseworkers. They either testify without their notes or they testify with their notes. Okay. It may not sound like a big deal, but it's a very big deal because if they testify with their notes, the attorney gets to look at those notes, gets to have a copy of them if they want, and can look at what they've got in those notes. Now, the same thing goes though for parents. I would always talk to parents about keeping a journal, keeping a timeline, keeping a calendar so that they had a good history of their case when they were preparing for trial. But here's the problem. I don't want a parent to keep a journal and then carry their journal to the stand with them and allow the other person to have access to their journal. I don't want the state to have their whole journal. So it's a little complex, but you still want them to keep a journal. And then we're going to make some notes from the journal, or maybe bullet points, some issues or dates, so that they have some reminders. Another thing that I would have them do is I would have them print just a month-to-month calendar, just a very simple one. I would typically just download them from the internet. Just download a form a month at a time on an 8.5 by 11 sheet of paper for every single month, and then just make a real short note on the dates that something occurred. If it was a visitation, if it was an email from CPS, because that would, and then they could keep their journal, because then they could carry their calendar on the witness stand, or they could, it'd be okay perhaps turning your calendar over, but typically you would not have to turn it over, because these are all things that were created at the request of counsel. So this is what's called work product, or created at the request of counsel. Now, a caseworker's notes are different, because those are government records about their investigation. So they can't keep those from you. And getting those notes and records during the pre-trial preparation of the case is absolutely a must, a critical, so that you have the opportunity to review them. So you will see if they're testifying with their notes, your parent attorney gets to take a look at them, and you'll find that there's hearsay from what other people told them in those notes, which may help you identify other people's records that you need to obtain, or other witnesses, if you've obtained those in advance. Okay, I hope this is not confusing. Sometimes it sounds like a lot of information, and I'm trying to break it down simply, but there's so much overlap here between the witnesses trying to testify and whether you get their notes or whether you don't. Okay. So testifying with their notes, you get the DCS records in advance, and here's what you see. And you see the DCS caseworker in her notes says, they usually call themselves CM for case manager. CM spoke to maternal grandmother on this date. Maternal grandmother says blah, 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 blah. Now, that's hearsay. She cannot testify to it, but it may identify that you need to subpoena that person to come to court to challenge what the caseworker has put in her records. Now, it could, go both ways, but typically the caseworkers generally are not going to make comprehensive notes, and there's going to be more information that's available. It also may clue you in to get other records, such as caseworker talked to school teacher who said blah, 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 or emailed school teacher. Now you know that you need to get those emails. If a caseworker or a visitation supervisor, for instance, gets up and starts testifying without notes, it's total chaos, because they just start saying things like, well, I made observations. I observed 3 visits, and, the parent was not redirecting their child when the child was misbehaving. But that's testimony. So that's evidence, but you don't have anything to cross-examine them with. So another super important reason to make sure pre-trial discovery is complete, so that if they have a supervised visitation person that's going to come and testify, that you get their notes and records in advance so you can cross-examine them. It's just absolutely dangerous. And then they'll give opinions and you have nothing to cross-examine them on. Total chaos. Total chaos. Now, as far as the parents are concerned, or the parents' witnesses, but let's talk primarily about the parents. If you've had them keep a journal, very important, about how the visitation went, what emails occurred, what meetings they had, etc., and they keep a journal, but they also have this month at a glance calendar where they have just written down, on Saturday, October the 12th, email from CPS worker. And then they've got on the 18th, they've got phone call with teacher. And then they've got on the 22nd, visitation with 2 children, 1.5 hours. Then you can very easily prepare a parent. And when they get ready to testify and they have that calendar in front of them, they can be much more specific. when you say, and you can even have them use a highlighter. For instance, you can have them put it all together and then you can say, okay, now go back through it because you know it's going to be months and months and months. And you go back through it and you say, okay, take a yellow highlighter, take a little yellow highlighter, and every entry that you have for visitation, highlight it in yellow. And then go get a pink highlighter. And for every email communication, highlight it in pink. For every meeting that you've had with CPS, Foster Care Review Board, plan meeting, whatever, highlight it in green so that when you flip through that calendar, you can find them immediately. Plus, it helps you know if they need to bring those emails, if you can see, okay, you've got 12 emails down here. I need to get copies of those emails because I may need them. We may need to exchange them. I told you there was a lot in this. This is why we're not only going to get to 20 slides today. All right, so another job is to stop incompetent testimony on records from coming in. The biggest one is drug screens. This is the demon, okay? This little pea cup you see right here, which are not extremely reliable drug screens. CPS workers leave them in the back of their hot cars. They get tainted. I don't know if these things are dated to expire, but sometimes they have them for months and months and months on end. Judges have even had them in their courtrooms. I've had them go in houses and take a pee test and leave the pee sitting on the back of the commode or on the counter as they walk out. You know, they're horrible. They're horrible. And yet they are repeatedly being allowed to either give answers about drug screens or submit their little one sheet. They have like this single sheet of paper where they look at the tab on the side of the cup that shows whether it's blue or pink or whatever, and they check them on a piece of paper themselves. And then the sample is destroyed. So the admissibility of drug screens is a big issue. I always object to drug screen records. Number one, typically, like I said, they don't send it to a lab. They don't test it in a lab. They often leave the specimen sitting someplace, and then they take a single sheet, a sheet of paper that where they write the name at the top, and then they check the boxes, and then they're just basically, it's self-serving, it's hearsay, it's not a business records, it's not a lab record, it's not a medical record. I always object to them, unless, of course, they're clean, right? Of course. All right, so there's no lab technician available to cross-examine on the process and false positives, which sometimes I've had to do. I mean, fentanyl is actually the big one is meth because there are a lot of cough medications that have amphetamines in them, and in some of these P tests, they will test positive for meth. Some courts allow the records saying they're business records. They are not business records. Most judges will overrule the objections, but you have to preserve the record for the parent by making these objections. Another place where drug tests have come up is sometimes they have not done an order for drug screens, but they just randomly call parents and ask them to come in for drug screens. And of course, if anybody's been through this, these random calls are very disruptive. I mean, parents who work or I had a case in close to Knoxville that this person would be called for a drug screen and the lab was 45 minutes away where they would have to go, or the office where they would have to go would be 45 minutes away. The same thing happens actually in Williamson County because they say, okay, you got to come to court and do a drug screen. Depending on where you are, I mean, we have people in Williamson County who work in Davidson County. If they're working in Davidson County, there is no way they're going to get in 45 minutes down to South Williamson County to do a drug screen. So developing the response, and I want to, I'm going to come back to this here for just a second because a good attorney is going to address some of these issues during the process before there's a final hearing. for instance, when the parent is they're preparing a plan for the parent, they will say, a good attorney is going to say, if they say, well, you're going to have to do random drug screens, you're going to have to identify criteria and the ability of the parent to take a competing lab screen immediately. Okay, so are these going to be admissible? Are you going to try to admit them? I'm going to oppose them. Are you going to say, I want the specimen sent to a lab? In criminal court, when they go to probation, and they do, and I had a guy go in on state probation. He did 3 different urine tests right then and there, and they gave 3 different results. And in criminal court, you're permitted to say, I want that sent to a lab, and they will have to lab test it. Now, there's a payment for that. So, and of course, most of these parents are strapped for money, but if it's a difference between getting your children back or not, it may be worth it. But how drug tests are going to be conducted, how much time a parent's going to have to report, whether or not they're going to be lab tested, whether or not they're going to be preserved, those are all questions that need to come up early in the case and not wait until the very end. All right, so developing a response. So, a proper cross-examination will help you determine what you need to rebut. Carefully identify the facts relied on by the social worker and investigator. So, ultimately, your question is going to be, so if blank were not true, then your blank would be incorrect, right? Okay, so this is a premise and conclusion analysis. So if all right. So let's say, I had a case one time where they were complaining that the child was not dressed properly for school in the winter time, right? The child only had a short sleeve shirt on. It was cold outside. And so therefore, my conclusion as a caseworker is they are neglecting the child by improperly dressing them for the winter time and for the inclement weather. And so when you listen to that very carefully, you can begin to identify that the facts that they're relying on are very limited in scope. And so if you can say, well, in your mind, you believe that on this particular day that the child's attire was not appropriate. And so therefore, you're assuming that in the majority of situations, it's inappropriate. But if that were incorrect, then your conclusion would not be correct as well. Is that right? I know it sounds like backwards doublespeak, but this is exactly where you want to go. If the premise is not true, then your conclusion is incorrect. This has to do with education, with mental health, with medical. I mean, it can be anything. It doesn't have to be one specific area. This is where they're going. So when I get back to talking about developing a response, when the social worker is testifying, that is, and it's hard for parents to sit and listen very carefully. Attorneys who are listening well always have a pad of paper and they have a line down the paper and they're writing what they hear on one side and they're making asterisks and question marks and little curly cues on the other half of the paper to draw their attention back to those facts. So this is something to always remember in the preparation of a case. If the premise were not true, then the conclusion would be incorrect. I'm going to give you just a very timely example. In medical kidnapping, there was an execution in Texas slated for yesterday, October the 17th, and it was stayed. This execution, after 22 years, was stayed 90 minutes before the time for the execution. But the execution was based on a shaken baby conviction that happened 22 years ago. and the father was autistic, and the little girl was 2. She wasn't an infant. And so I've watched the stories about this, and this whole premise were about how the baby was shaken because shaking a baby is the only cause for these fine blood vessels in the brain to rupture, therefore causing these cavernous pools of blood inside the brain. And so, therefore, our conclusion must be that the father shook the baby and caused this injury. So, in watching the story about this case, they actually there's an email listserv on shaken baby syndrome, and we've had some very good doctors speak on this. But in this particular case, this baby had been given some very strong medication and just days before, and been giving more medication that was permitted to give a child her age. And so there's a doctors who now say this is you had the wrong premise. There could have been other things, other mechanics and other biological things that were happening. So therefore, your conclusion that this father killed his child is incorrect. We'll see how that turns out. Like I said, they just stated they've had lots of chatter about it, so I'm not sure where that's going. But this is so important. Write this down, write this down. If the premise is not true, your conclusion's incorrect. All right, wearing the witnesses out until they waiver. This tactic is used by state agencies on parents and children, unfortunately. Questions are asked over and over. The tenor of the questions can become more aggressive or more confrontational. The techniques are used to get the witness irritated, snappy, and confused. The other thing on the tenor of questions, I have seen sometimes with a child, it's not the aggression with the child. What it is kind of hmm, they try to put the child in a almost an over friendly state so that they can then get the child to agree with the questioning, the direction that they want to go, as opposed to having the child stop and think about what's happening. But this is like the example that I gave you before. They believe if they can get a parent irritated, snappy, and confused, and especially dates, if however they can confuse a parent, if it's confusing them on the dates when something happened, if it's confusing them on the parent's recollection of what somebody said, anything that they can do just to cloud their mind is going to then be an attack on their credibility. All right, the verbal diarrhea of blathering liars. And I've had these as well. So, blathering lies do not need airtime, period. End of story. If the witness is just lying and repeats the lies incessantly, just shut them up, especially if you can rebut their lies with other evidence or other witnesses. Here's this little cartoon showing Pinocchio up there. Perhaps you'd like to rephrase your last answer. I've had cases where they just talk and talk and talk, and do not, um, they don't answer the questions directly. And it's like anything they say, they just go on and on. These are the types of witnesses where, after the state has called their witness and it's time for the parent's attorney to cross-examine them, you say, Your Honor, I have no questions. What does that do? It stops it right then and there. It absolutely stops it, because the state cannot get back up and ask more and more questions. The state loves these witnesses. This can be a caseworker, it can be a foster parent. It's usually somebody who's, I mean, even supervisors, I've had it happen where they just get up and talk because they know if they have to be specific, and if somebody can can easily cross-examine them, they're going to fall apart. So just stop it. Just stop. No questions. No more questions. And I've had situations where I've been able to get up and ask maybe two pointed questions and ask those two questions, no more questions, sit down. Because remember, when the state gets back up for their redirect or rebuttal, what they're supposed to do is limit their rebuttal to the questions that were asked on cross-examination. They're not supposed to be able to just get up there and blather and blather. The state loves to eat up time. They love to eat up time. They know if it's a court-appointed attorney that they are limited in the amount of time that they can bill for. They know if it's a retained attorney that they're wearing out the parent financially. So they want to go on and on and on. All right, so social workers and investigators, they are not experts. So investigators are the ones who make the initial contact, so usually the ones who take the children, do some of the interviews with others. But the state agencies, after they remove the child, the person who takes over the case is typically, I put here a social worker. They're not truly social workers, but they are care or case managers is what they even refer to themselves. Most of the time, they don't even call themselves social workers. Rarely are they experts in anything, but some agency attorneys try to qualify them as experts or ask them opinion questions. I have seen this of late where the state gets up and asks a case manager, how long have you been a case manager? How long have you worked for DCS? How many children have you had in DCS care and custody? So, and then try to qualify them as an expert in social work because they're DCS case managers. They're clearly biased. So experts, again, we'll do a whole thing on experts, but the difference between experts and lay opinion is what you're looking for. And I think I have a slide on that. So let's pop over here. I do. Fact witnesses versus expert witnesses. We're getting close, guys. Hang on. So in the rules of evidence, there are lay opinions and there are expert opinions. So lay opinions is something that somebody can testify to just because they live life. Okay. It was a long day. I was driving fast. It was darker than normal. The guy that passed me, had to be doing more than 70 because I was doing 70. My child was hot because they were sweating. All right. Those are just lay opinions. The expert opinions are opinions that require a higher level of education and expertise. Now, expert opinion is a little bit different between states and federal. But generally, it can be an expert in a whole wide variety of things. It doesn't necessarily have to be medical, mental health, opinions. It can be opinions on, it can be education. All right. You can have an educational expert. You can have an expert in play therapy. Okay. Or there's, in trauma and separation. So there can be different kind of experts, but they are opinions that require them to establish an education and experience background to show that they have a higher level of expertise than the normal average layperson. The state agency will attempt to get in opinions, and these are mostly expert opinions, on the long-term effects on children that have been in foster care, the parent-child bonding, the attachment disruption. But the attachment disruption is typically the foster care attachment disruption, not the parent attachment disruption. They will attempt to qualify the social worker as experts. If they do, the parent's attorney has the opportunity to what's called voir dire them strictly on their qualifications. So if a DCS, if a state agency tries to qualify a social worker, the parent's attorney just says, I would like to voir dire them. And then you get to ask them questions. And those kinds of questions, primarily, you start with, isn't it true you're not licensed as a social worker in the state of Nevada, Tennessee, Illinois, wherever it is? Because none of them are licensed social workers. But you do want to also, that gives you the opportunity to also ask them. So if you're an expert in social work, I am going to assume that you are following the ethical standards of licensed social workers. Is that correct? Even if you're not licensed. So you want to be prepared, and you want to study up on what those ethical requirements may look like, because they are going to include conflicts of interest, etc. So from there, you'll be able to follow up with cross-examination questions about conflicts of interest. So watching how the state handles their caseworkers and trying to qualify them as experts is critically important. All right, opinion versus fact observations. Here's another one. Another one they love to use, especially about children. So, actual fact observations are things like physical reactions, emotions, and words of exclamation. A child is crying. A child has a look of distress on their face. A child had tears coming out of their eyes. The child screamed and was loud. The child yelled, Mama. The child yelled, Don't leave. You know, they love these to try to get in when parents have not seen their child regularly and they have a visitation. They love to then say, Oh, well, we can't continue visitation because of the child's adverse reactions after visitation. What they cannot do is a lay person cannot testify when they've seen a crying face. They cannot say, well, she was afraid or she thought she would be hurt. What is more accurate, and the cross examination of these witnesses, is something like, well, isn't it just as likely that the child did not want to leave their parent, that they felt some separation anxiety from their parent? You know, these are little clues I'm trying to give you, because over the years, hundreds and hundreds of cases, watching all of these mechanisms going on in the courtroom, these are the actual things that happen. My taking these and breaking these down for you like this, which is a challenge for me, I will tell you, but is to try to help you think in that very intensely about that whole entire process, because it's a science, okay? And you need to think about it as a science and tear it apart like you would a science experiment. All right, so again, opinions versus fact observations. If a witness starts to testify about that, you want to confront the witness about making assumptions from observed behavior, such as you don't know why she's crying, maybe she misses her mother. You know, in evidence, there's another objection, which is you cannot assume. One person cannot testify about what another person is thinking or what is in the mind of somebody else. And so that is also a relevant objection to that. But typically it's like hearsay, even. They don't even know. So, but you want to be prepared to cross-examine them. And the biggest one I've seen is the children, how they are using these observations, and sometimes not even real observations, to try to paint the picture that they want painted in court. All right, having the records in advance is an absolute must. This is a little picture here from a DCS record. But having an agency records in advance of trial is a must. There are errors in data, there are inconsistencies in the investigation. The records need to, you'll see in the records other people that need to be subpoenaed that might be involved in the case, and also any prior history with CPS and what their records actually reflect. And this is just a little sample. So in this reflects that there were prior investigations, and it says here allegation unsubstantiated, perpetrator unsubstantiated. This one was allegation substantiated, perpetrator substantiated, et cetera, as you see here. So the other part of this document would say what those records are. Now, you can see here also interesting. I find this interesting in the actual records. You can click right there and you can reclassify. I don't know what the standards, the policy and procedure are for doing that, but you will be able to see um, what kind of history a family has had with CPS. All right, and I think this is our last one. This is just another short example of what something looks like from a CPS investigation. This is what the top of it looks like. They're called case recordings. And this is important data right here because there is a contact date and there is a created date. Now, this one was fairly quickly. This was 10/4 was the contact date, and the actual record was created on 10/5. However, I have seen these two dates differ as much as 60 to 90 days. And so those are really good questions for cross-examination. It also will tell you, now here they should have the duration, whether or not it was face-to-face or email, etc., phone call, and where it occurred. All right, so not just when you get the records, you want not just case recordings, investigation records. There are lots of things you want to ask for. They have another document called a FAST tool. They call it a communimetric tool, and it's like the CANS, which is children in need of assistance, children I don't know, acquiring, and I don't know what the A stands for, and the adult needs and strengths assessment. And it is designed to maximize communication about the needs and strengths of families. The FAST includes ratings on family together, each individual caretaker, and each individual youth. This would be a very valuable tool if it were used properly. What I have seen of these FAST tools is they do a lot of copy and paste. They do a lot of copy and paste of all their records, as a matter of fact. But you want to make sure, for instance, when getting case recordings, investigation records, you ask for the FAST tool. Other records you want to go ahead and ask for are emails, ICPC requests and reports, foster care review board reports, any Title IV request, RFPs for services, which is request for payment, RFPs for services, reports and opinions prepared by anybody else that they have relied upon, any staffing notes, text messages, audio and video interviews, and the PTSTD, which stands, I don't know the exact acronym, but it stands for their report that they've created on what the needs of the child are for their medical, dental, and mental health needs. If you just ask for their investigation notes, or if you just ask for their case recordings, they're going to try to limit. I used to have DCS give me entire box loads of records, and they would include emails and meeting notes and RFPs. And I have received some very damning information against the agency through the internal emails that they were sending. But now they will not send those unless you specifically ask for them. All right, so this takes us, I know you're all are going, thank you. It's been an exciting afternoon, but this takes us to the second section, which will be the authentication of records. So this is very, very important. Y'all have been very patient, very attentive. I appreciate that. We are going to do authentication of records next week in our session. So we're going to end this one. I'm going to go ahead and stop the recording.